my guess is that even if we were to finish this agenda, which is a big if, this morning, we would still have to come back later this afternoon after the 1:30 appropriations meeting. So just stay tuned for another called meeting in just a little bit. So we're going to jump around a little bit. If we could, are you ready to do? Yeah. Let's jump to House Bill 630. And this is a doubly preferred bill that came to us from elections. And we're going to ask the Vice Chair, Senator England, to explain.
Thank you, Mr. Chairman. What we have, we do have a strike call that came to us from the Elections Committee. This bill allows, whenever a person has gone through the expungement process and has a crime expunged by that process, this clarifies that they can then be allowed to become a qualified elector and vote again. The strike call, if you'll notice, it's just on line 64. It says, including those laws regulating qualified electors. So this just directs judges and directs everyone else to understand that when you have an expungement, it's including laws regulating qualified electors. And that's essentially all that this does. It allows for the process to go forward once someone's gone through the expungement process.
Okay, thanks for the explanation. I have a question about that. I talked to a few of my circuit clerks last night actually, because I saw this was coming. So the process, I understand it now, you go into the circuit clerk's office and you say, I want to register to vote. If you've had a disqualifying conviction, when they punch you into the SIM system, red flag type situation comes up and it literally refuses to allow you to allow the clerk to register you due to this disqualifying conviction. And if I then say, but my conviction has now been expunged, I want to register to vote, I'm told that typically the protocol is the circuit clerk then contacts the county of the original conviction to verify that in fact the crime has been expunged, and if it is, then SIMS is the one that has to update that information, because like physically the clerk can't register you in the SIMS system because there's like essentially a block on it due to that disqualifying conviction. So it's not necessarily that the clerk can override the system, like they have to contact whoever manages SIMS, which I guess is the Secretary of State, and prove or provide proof of the expungement of that said crime. And then once the block is removed, then the circuit clerk can register that person. Am I understanding that correctly?
That's my understanding. I don't think that the process that you just outlined, I don't think is at all affected by the bill. I mean, it just allows it for, if you have the expungement, then you look back at those laws regulating qualified electors. And I have that statute if anyone would like to look at it. But based on what you said, I don't believe that would be affected at all.
So I guess my question is, why the need for the bill? If that's already the process, if a clerk cannot prevent you from registering once the previous crime has been expunged, this bill just says they can't. I mean, I think they already can. So I guess my question is why?
So I believe there are jurisdictions in this state where a judge maybe is not putting that in the expungement order, perhaps, that this would allow them to do that. If they reference this code, it does say, including the laws regarding qualified electors.
But even if the judge does not say that in her order, if the crime no longer exists, it's no longer on the record, and you prove that, I mean, I'm not against the bill. I'm just thinking, why is somebody not registering that person now, even if that's not in the order? The crime never existed once it's expunged, correct? So why is a clerk out there not registering somebody?
Yeah, Mr. Chairman, I think that's an excellent question. And I would say that that after my conversations with with Chairman Bain on the other side, who had this, he agreed with the sentiment that with an expungement, the purpose of expungement is to put someone back into basically the same situation they were in prior to the crime that was expunged. If they were allowed to vote at that point in time, then it would stand to reason that they should therefore be able to vote after the record is expunged. But it was my understanding there are certain instances when this does not happen. I'm not sure of the reasons as to why that has become an issue. It may be jurisdictional, maybe there are specific jurisdictions where this is, this language may be geared to help. And I would say that if you look at the committee substitute that came over to us from the House and what we've done, we have tightened this bill up an awful lot to where it's just one line being changed as opposed to several pages of that. And I think that was through work with the elections chairman and our committee assistant on that. But I guess to answer your question, my answer would be that's a very good question.
And my follow-up question to that is, y'all may have cleaned this up a little bit because of this concern, but if I'm one of those persons that has been previously disqualified, now we're going to pass a bill saying you must be allowed to vote, even though I think you already are, must be allowed to vote. Is a list going to be created to circulate to the circuit clerk's offices that says Joey Fillingham, previously convicted of X crime, has now been expunged of X crime, and so therefore when he shows up at your office, do not let him register to vote? I mean, I don't want some list floating around that permanently sort of scarlet letters these people and says, okay, well, she was a terrible, criminal previously, and now she's expunged, so you must let her vote.
That's right. Yeah, I don't. As a proponent of some lists and not others, I think that would be a bad list.
And I think the House version actually had a list in it, did not?
But if you look, I'm not sure if the House version had a list. I would take your word for that. And yeah, so it did have a list of those available. So that has been at least taken out of this version.
I just wonder if, practically speaking, even though we don't say that, that's what's going to have to happen in order to carry out the dictates of this law, thereby having an unintended consequence that continues to scar some people with said lists floating around. All right, Senator Sparks.
Thank you, Mr. Chairman. We can, I think, cover all those bases by directing the Department of Public Safety through the NCIC to forward the expungement to the county of conviction, because they already have the duty to report it to other agencies and also to maybe the FBI to pull somebody's fingerprints. So I think that not needing legislative action to do that, I think DPS and through NCIC would do that, because you are very correct. We do not want to create a list. And the truth is, when you do an expungement, if I call a county where I've expunged a case for a client, that county's not even going to acknowledge the case existed because it's as if it never happened. So that would be one reason you'd have a hard time getting something out of Sims, is because the county where you expunged it technically is not supposed to admit it even happened. But if NCIC would take that role, it would solve this problem. And I think the legislation would clear up where the problems are, and then DPS can cover that base. Be mine.
So who manages the SIM system? Is it not the Secretary of State's office?
Very well may be, but if the Department of Public Safety through NCIC contacts them,
But is that what you're talking about?
no, sir, no, sir. I think that they would, based on the language of this law, and we would ask DPS. I was looking to see if anybody from DPS was here. That is something they could do, because it's a similar function to what they already do for expungements.
Okay, other questions, Senator Hill?
My question would be, sort of like you were talking about, the time lapse between when the expungement would happen and when it would actually get processed through SIMS, that the person would be showing up at the circuit clerk's office demanding to be able to register to vote. And if that person in the circuit clerk's office could not do that, it could create some issues for them in the clerk's office, because if they think they're supposed to be able to vote, they don't understand why you can't do it if it's not straightened out in SIMS. So, I mean, to me, there may be some type of time frame that may need to be put into this that would, give some leeway to DPS to get this straightened out in this system. Because if you're going to have to go through them, then the Secretary of State's office, it's not going to happen yesterday. And that person may think that they can immediately go and register to vote. So I don't want somebody threatening the circuit clerk because they think, because this law's passed, that they can automatically go vote. So that would be my concern, that there needs to be some kind of time lapse that the person's aware of, that they can't just walk straight to the clerk's office and register to vote. That would be my concern, and I don't know quite how to address that, but I think put some kind of time frame in there might take care of it.
Thank you, Mr. Chairman. I do see we have a representative from the Secretary of State's office here, Colton. Do you guys have any comment on this bill at all, one way or the other? No. Okay, thank you.
Let me ask you, Colton, do y'all manage the SIM system at the Secretary of State's office? So when someone's record is expunged by court in the state of Mississippi, I guess a circuit court, maybe county court too, is it county or just circuit? Both, I guess. Do they always send y'all notice that said crime has been expunged for purposes of making sure that the block is removed from the SIM system? All right, Holly just recently left the Secretary of State's office and is now with us. Holly, can you shed some light on that situation? At Mardi Gras.
Mardi Gras.
Thank you, Joe.
Full disclosure. Thanks. Senator Turner for.
Thank you, Mr. Chairman. So is there another code section, or does this code section outline the processing of the order? Is that procedure spelled out anywhere?
The vice chair or council?
Now, if I can ask, the procedure that you're talking about, is that the procedure to become a qualified elector?
No, once the order is entered by the circuit court, expunging the crime, so is there any directives in terms of how that order is to be processed? I know it's going to the AOC, but it hasn't been specified what has to occur with the order. That's just how it's like any conviction that comes to the circuit court. They have to So is there something that we may need to specify in the code, certified copies of the order are to go to it takes place? Just to make sure that there's a clear process, because it's just being entered along with all other orders. We need to have something in place to draw special attention to this.
I think it's a good question. I
think it's a big difference. I talked when this meeting that one thing's function or happen and the AOC must the Secretary of State for sense purposes as well as the circuit clerk of the county commission.
That would be my amendment.
Sorry. Any questions on Senator Turner's amendment trying to clarify this whole procedure?
I have a question for policy advisor on. It is on the amendment. So you said that it goes to AOC, does it still go to DPS? I mean, I've been doing expungements my entire private practice. And the order will leave the circuit clerk's office and will go to the Crime Information Center of DPS. And the reason for that, because DPS also makes sure it goes to West Virginia, where we have the NCIC, which is the National Crime Information Center, to get it completely removed off their state and federal record. And the reason I raised the question during the amendment, because I do think it's really, really important in these type matters that all of the places that would need the actual order receipts or effectively answer my question.
I will make the motion of title sufficient do pass as amended. Strike all as amended. Aye. Glad to do it.
All right. Moving along, let's see, if you'll go over to 672, this was a doubly referred bill that came to us yesterday from the Public Health Committee, and some of y'all were probably in there. It started out, quite honestly, as a bill that I think had a lot of concerns, raised a lot of issues, mandating a specific type of rape kit to be used in the state, and there are a lot of questions that I had, that Brian had, and I think our medical providers had. Is it, I think the purpose, I think the stated purpose of the bill, and I've spoken to Chairman Cockerham numerous times about this. She's very passionate about this piece of legislation. I think her goal is to make sure that rape cases are prosecuted, and she believes that there's no sort of central process for doing this, that there need to be some guidelines established so that when someone is raped, there is a protocol of a certain type of rape kit, who handles that. It just doesn't sit in the back of someone's patrol car for a couple of weeks and deteriorates, so there's no longer any use in the prosecution, that sort of thing. So that is her concern. I think it's a very valid concern, and absolutely we wanted to help her keep her bill alive. I think Senator O'Brien had the same conversation with her, but the way in which the House bill is worded certainly raises a lot of questions. So what happened in the Public Health Committee yesterday, you'll see on the committee's, it's just one page. It essentially establishes a study committee. The Commissioner of Department of Public Safety Director established a task force to study the laws and practices concerning sexual assault evidence, and report its recommendations to the legislature on or before October the 1st of 2022. And that's what strike all does. I have shared that information with Chairman Cockerham. She's very thankful. She wants this bill to continue to live, maybe to be addressed further in conference if this committee in the Senate sees fit to pass it out in the study committee version. But that's the version before us, is the amendment that came to us from Public Health, which strikes the original bill, all the specifics of it, and inserts a study commission to study this issue, to report back, presumably for action next session, if action needs to be taken. So that's what the strike all from Public Health does. I'll be happy to try and answer any questions about it. Not for the motion, all in favor say aye. Any opposed, nay. The ayes have it. Thank you very much. Yes, let's go on down to House Bill number 980, and we're going to recognize Senator England to handle this one. I'll say there was a similar bill Senator Bryan had passed, that this I think is very similar, and maybe you tell us the differences between the two versions that I will recognize.
Yeah, thank you, Mr. Chairman. I'm not sure I can speak to the exact differences, but the bill is very, yeah, shall versus may. Well, so it is a very minor, it's a less than 2-page bill. And if you remember when we debated this on the floor, it says in the event of a classification or declassification of controlled substance on the federal schedule of the controlled substance, the federal government makes a change, the state health officer in the state of Mississippi may issue an order that mirrors the federal action. And it would last for a period of 2 years, would allow us to come back within those 2 years and make the change permanent or to amend the change that has been made by the state health officer. And I would say just the policy behind this is that when a drug is moved up or down on the schedule, if it allows medications that weren't previously allowed under the schedule to Mississippians that could use the benefit of the drugs, I think it's a good policy to have, that we at least allow our state health officer to have the option to make that change. It doesn't, again, our bill said shall, and we had a reverse repealer in our bill that passed on the floor. This one says may, which I believe addressed the concerns that we even had on our floor. So that's the description of the bill. I'm happy to entertain any questions.
Good explanation. Any questions? None.
Title sufficient do pass.
Heard the motion, all in favor say aye. Aye. Any opposed, nay? The ayes have it. All right, let's jump over to House Bill 1021 and Senator Sparks, if he would be so kind as to enlighten us on this bill.
Thank you, Mr. Chairman. Senate Bill 1021 addresses the bail procedures upon arrest, and what we're trying to do is mirror greater the intent and impact of the criminal rules that came down from the Supreme Court in 2017. So this is a strike all, but if you look at line 68, I printed this out this morning, this is the same line you have, which is language very similar to Rule 8 of the Mississippi Rules of Criminal Procedure, is that the defendant or counsel asserts the defendant is indigent, he cannot afford the amount of bail. This is dealing with the municipal judge, shall make a determination on how that defendant could be released based on factors in Rule 8, the Mississippi Rules of Criminal Procedure, and any other factors, including the availability of third-party support system to obtain release. That's one of the things that gets overlooked sometimes, is that if someone has a third-party support system, parents, et cetera, that they should utilize that to make bond. And certainly it's the duty of the municipal judge to ensure the release of the defendant does not jeopardize the community. Now, C allows the defendant, the accused, to waive a personal appearance before the judge and execute an appearance bond in an amount determined by the court's designee. What is happening is there's a 48-hour rule for someone to see the judge, have their bond set. If the defendant does not want to wait 47 and a half hours potentially, and there's a bond that can be set, that person would not miss a day of work or things of that nature. So it allows the defendant to maintain that right to see a judge, but they can also waive it if they would rather have a bond set, again, in accordance with Rule 8 of the Mississippi Rules of Criminal Procedure. D addresses the issue if a judge is unavailable, that the judge, and it's already existing law, that a judge could, by order, appoint someone to apply a bond or to appoint a bond, but that amount must be in the recommended range of Rule 8 of the Mississippi Rules of Criminal Procedure. A judge can go outside of that recommendation. His designee should have to stay within that recommendation because they're not the judge. Then in subsection E, we're dealing with crimes of violence against family members. You have to check a database to see if there's prior domestic cases before you address the bail or bond issue. That is primarily what is in, section 1. In section 2, we address that defendants sometimes are asked to post cash bond only. Well, to use cash bond only as a surety, it needs to be where someone has failed to appear prior, or they're subject to a show cause hearing in that court, or for any other good cause shown by the judge that they put in writing. So there are times that is needed, but once again, it's not something that should just be applied to everybody that walks through the door. There should be a reason. Then in section 3, we're dealing with justice court, and it does the same thing, because sometimes if you're arrested in city limits, the municipal court judge will set that bond. If you're arrested in the county, the justice court. So if you see A, B, and C, they do the same things we just described. That's a explanation of the bill, Mr. Chairman, and I would yield any questions.
My question is, would you consider this bail reform?
I don't know that it's reform as much as it is trying to adhere to the rules of criminal procedure from the Supreme Court. One of the things that we have is, we have a lot of municipalities and justice court judges, and sometimes they seem a little paralyzed about what the new rules mean and what I can do, what I I cannot do, because they're trying real hard to honor what has been sent down by the Supreme Court, which is still relatively new because they came out in 17. But this guides them to say, you know, look to Rule 8. Let's not leave people in jail just for the sake of having to see a judge if they had rather have their bond set within that range and then be able to bond out.
Senator Hill?
Basically, I would have the same question that you just posed, is this bail reform, and it certainly looks like bail reform to me. And what my concern would be is these same policies have been passed in other states. And if you look on the news, you will see people who are shoplifting and purse snatching that have been arrested 47 times, that are accosting people in the subway. It might not be a felony, but it's certainly something that's infringing upon somebody else's rights and livelihood. And my concern would be that every judge is not going to take into consideration how many times this person's been arrested. If they're indigent, they're indigent, and they may not have bail. So my serious concern would be that this could set up a situation where we have repeat offenders for shoplifting, purse snatching, some of these misdemeanor crimes, that we could get into this same pattern that we're seeing in other states. And it concerns me greatly, because just because somebody's indigent doesn't mean that they are not going to commit multiple crimes. And if they're not going to have to post bail, there's nothing preventing that from happening, because if it can happen in another state, it can happen in Mississippi. Because, I mean, people break the law here just like they break the law. And we have some judges that are, and DAs that are, you know, diligent about looking at past records, but it's blatantly obvious that some don't. So that would be my concern.
Senator Sparks, go to.
If that was a question, I didn't hear it. If it was a speech,
Yeah.
I'll reply.
It's both.
I will 100% disagree. The short title aside, this is pointing to the rules that have been put in place by the Supreme Court. It does not create a revolving door for no bail, which I oppose vehemently. This allows someone to have their bond set within the guidelines of the Supreme Court, which also take you out of the issue of, well, we're just going to release you on your recognizance. One of the things we put in the bill addresses Senator Hill's point, is that we're telling the judges, which I don't think it's done often enough, that you need to consider third-party support in setting a bond. You can't just walk up to the judge and say, I can't make that bond. So I think it actually strengthens it. So when I say I disagree, I understand her concern, and I actually share her concern. I would not put forward anything that would put us in akin to other regions of this country. But I think this bill is an attempt to streamline us with Rule 8, which we have to follow whether we like it or not in the court system. But I also think it allows for us to draw distinctions when they need to be made, including, and I think this goes back to Senator Hill's point, requiring a cash bond if you show a reason where someone has been a repeat offender when they haven't come to court. That's the basis of it. So actually, I think she would, I don't want to speak for what she would do or not do. I think it addresses some of her concerns in a positive manner.
Another question, Senator.
I have a question and then an amendment at the proper time. My question is really, if they can answer it in here, where's the bail association on this? Is this something that they brought forward, or is this, where are they on it?
I think Mr. Sage maybe is here with us. Would you like to speak to Senator? We can.
is, over the years, we've done some bail reform in terms of the bail association membership and all. Is this a good, is this part of that? I guess I would say.
In terms of association, and the license, department insurance, that's kind of the regulatory side. This is strictly up to the
Okay.
So there's several things. This is not say well, an issue that is not affected by
This is going to the criminal side. This is going to the criminal side of that, not the, okay.
There are, well, it's in this.
Right.
Municipal language, I think it's earlier about this, but it's been there for a long time. It has not been. So what we wanted to do is basically make those two statutes very good. There's a provision that does that, not in municipal statute.
Okay, so I have an amendment at the wrong time.
I do have a question. I'm reading line 77 through 92, and that's a dangerous thing to do to read a bill. But it talks about indigent, people in those lines, and it also talks about waiving an appearance bond, waiving an appearance before the judge and executing an appearance bond, and that they would agree to appear at a specified later date in front of the judge. So I'm real confused about some of the answers that I've gotten. Can somebody clarify what that section does, if I'm interpreting it wrong?
Subsection C or paragraph C,
Yeah, C and D.
C and D. Okay, again, the defendant may waive an appearance before the judge. If they do, they're gonna have a bond that is set within the recommended range, so they're gonna have to post a bond. All we're saying is, you don't have to wait for the judge if the judge has designated someone to set that bond. Because some people are sitting in jail, you get arrested on a Friday evening, it may be Sunday evening before you see a judge, but if, the defendant, they say, look, you want to let them set a bond, they can set a bond, but that's not waiving bond.
So who's gonna allow it besides the judge? Who's gonna determine?
The judge would designate someone, and that goes back to paragraph B, that by order, in A, they would do that. So
Who is they?
the judge would designate someone via court order, a specific person to do that.
So would it be court clerk or?
It would be whomever the judge, it would generally be someone that would be at the detention center. Because that's where the action would
So
happen.
they could basically post bond without seeing the judge and be out before the judge made any determination. So that would be my concern. Thank you.
Yes, and I'll state my amendment and then be allowed to explain it. So my amendment is gonna be that throughout the amended section, that it say that nothing in this law will be counter to, section 29 of the Mississippi Constitution. Let me explain that. Section 29 of the Mississippi Constitution is entitled excessive bail prohibited, revocation, or denial. The point of that section is that know that the judges can, when it's a crime that carries 5 years or more, then the judge, that lays out what judges can do and what they should do. Okay, so for example, if it is, and I'll just read the section, excessive bail shall not be required except for capital offenses when the proof is evident or presumption great when the person has previously been convicted of a capital offense. Bottom line is, bail can be denied on capital offenses. And as I read the bill, there's nothing in here to say to keep that in place, other than it's the Constitution provision. provision. And judges, I'm sure there will be a lot of misconstruing of the statute. And also, if you're already on bail and you commit a crime that is that carries a penalty of more than 5 years, then under Section 29 of the Constitution, a judge can deny bail. So if you're already out on bail and you commit, let's just say you commit a grand larceny, the judge under the Constitution can deny that bail already. So I am concerned that the language that's in the statute doesn't do that. And I think that my amendment actually addresses what Senator Hill is trying to say. And that in my amendment, then what we end up dealing with are those crimes, if the amendment carries, are those that only carry less than 5 years. And that people are, and basically first-time offenders. Because in Section 29 of the Constitution, it does list out, it says in Section 4, in any case where bail is denied, the judge shall place in the record his reasons for denying bail. Any person who's charged with an offense punishable by imprisonment for a maximum of 20 years or by life who's denied bail shall be entitled to an emergency hearing before a justice of the Mississippi Supreme Court. So there are provisions within the Mississippi Constitution that allow that. I will say this, from having many of our bail decisions, particularly on capital, are handled through city courts and justice courts. And as we all know, judges in justice courts are not, many of them are not lawyers. Okay. So it does get very convoluted and it does get very serious. And I also know, because I've seen it, is that I shouldn't say city, the lower courts will set an artificially high bail just for the reason to keep people in jail. And then you have to go and you have to petition and you have to go through that. And I think what Senator Sparks or this bill is trying to get at is those in particular where it's artificially set high just for the heck of it. So with all that being said, my amendment is that none of this conflict with Article 29 of the Constitution. Okay, Senator Simmons, I believe that's
Thank you, Mr. Chairman. And I don't know, I guess the question would be to the attorney. But I thought we were all doing statutes. And are there any other statutes where we actually have to put language that they should not conflict with the Constitution? I mean, I guess I'm thinking about just Constitution by 101. There's, if the statute is in conflict with the Constitution, then the statute can be declared unconstitutional. So, but the reason why I guess we enjoy putting things in statute is because it gives us the opportunity on an annual basis to correct what we've done. Article 3, I'm very familiar with that, with the section that Chairman Wiggins mentioned, because it's used a lot to revoke bond. When a person has, a bond has been set, and he or she gets a second bond while out on bond, prosecutors in front of a circuit court, they will argue to revoke the bond.
It also allows defense attorneys to charge for another case too. So.
Right. And so that process, I agree with Senator Wiggins. I just don't know if it's necessary just to add language in the statute that it should not conflict with the Constitution.
Well, to my friend Senator Simmons, I think he would admit that there's a lot of in those courts, things move fast. And it's my experience, and I think his experience, that they don't always pull open the Constitution, and a lot of mishandling gets done. And so by having that my amendment in the statute, they open the book, they can see it right there and says this shall not conflict with Section 29 of the Constitution. Because if, let's take example, the Justice Court judge who's not a lawyer, even though they have training, they're all good people. The reality is you would have to go to 2 different sections, look at that law, and then you have to go to another one, you have to go to another one. So by putting it in my amendment, you put it in there and it's there and there's no question.
I guess just as it relates to the amendment, I don't have a problem with the spirit of the amendment. I think it may be a bit superfluous to add it just because of what Senator Simmons said is that the Constitution is still the Constitution. And as it relates to the felonies, they have to set a bond if someone's entitled to bond on the new felony. It's the felony they're out on that they revoke. That's and the Constitution allows that. And by the way, that's a non-appealable issue. The district attorney recommends that, the judge orders it, and you can't do anything about it. There is no appeal on that. So I agree, if somebody's out on bond, on felony bond, and they catch a new felony, and the state elects to revoke that first bond, there's nothing the judge can do, the justice court judge or their defense attorney. But I don't have a problem with the concept. I do think it's superfluous.
If I may, but I think that's what goes to Senator Hill's discussion for those non-lawyers, although she's probably studied to be the lawyer. I think it causes a lot of confusion. And so by having that and that provision, just what you say, by revoking the bonds, this revolving door can be stopped. And that's done by Article 29 of the Constitution. I think that would be a good thing. Any other questions on the amendments?
In relation to what you're saying, I think it would probably be good to add it because there's nothing in this language that basically says if they're already out on bail. So it just says
That's
if they
my
can't
point.
afford it. So I think you're going in the right direction.
That's my point, and I think most lawyers and judges should know of the constitutional provision, but that's what I'm saying. I think I certainly have seen it, and certainly for our non-lawyer colleagues, non-criminal defense, when you look at this language, there's some questions about it. So that's why I think it's part necessary.
But it still doesn't mean that they're going to adhere to it. But if it's
Correct.
written down again, it might clear up some confusion with, like you said, some of these in the lower courts.
I agree with that, not to belabor it, but I certainly think that if it is violated or they don't adhere to it, then defense attorneys can hold their feet to the fire through a constitutional provision.
All right, any questions on the amendments? If not, you've heard the amendment. All in favor of the amendment, say aye.
Aye.
Any opposed, nay. The ayes have it. All right. Any other questions? Back to Senator Sparks, Senator Barton.
Thank you, Mr. Chairman. Senator Sparks, you were talking about the judge can appoint a designee to make the bail. What's the necessity? Why do we need a designee when we have a judge?
Well, the judge via court order could, because the judge may be on vacation, the judge may be out of town. He or she already has that authority to appoint a designee in the municipal court, and we added that authority. The issue being that if it covers two things, it covers the 48-hour rule where someone is required to be brought before a judge within that 48 hours, but it also allows somebody that gets arrested on a Friday night to bond out on a Friday night or a Saturday morning if it's an offense of which the judge gives them the authority to set that bond.
In my experience, there's been, like a justice court judge, there's always more than one justice court judge per county. There's always, if somebody's out sick, they can always set that schedule. So they can always work stuff like that out. But does this designee have the same training that the justice court judge or municipal court judge has?
No, they wouldn't, and that's why they're limited to set something within the range. But also, I make sure that this doesn't require anybody to do this. We're just offering them the ability, if that would help, I guess, alleviate any concerns on bond. We're trying to follow the criminal rules.
I like the bill. I just don't know that we need to have a designee there. I mean, they're elected or appointed. They're the ones that know the law, that know the training. And it goes further. I'd like to just look at that and figure it out.
Thank you, Mr. Chairman. I will.
Any other questions? Not Senator Sparks, got to close.
I would just ask for title sufficient to pass, strike all as amended.
You heard the motion, all in favor, say aye.
Aye.
Any opposed, nay. The ayes have it. Thank you for the good discussion. Let's see, let's bump over to House Bill 607. We're gonna recognize our esteemed legal counsel here to explain the Parker's Law strike.
Thank you, Mr. Chairman. Parker's Law creates the crime of fentanyl delivery resulting in death. There is a strike all, and there was no companion Senate bill to this, so this is new language that you all are seeing. I guess the easiest way to do this would be explain the differences in the strike all and the bill because they're simple. We added a knowledge requirement that the person delivering the fentanyl had to know that there was fentanyl in what they were delivering. And then we also defined fentanyl, which we'll get to. So subsection 1 on line 8 says a person who delivers or causes the delivery of fentanyl with knowledge of the fentanyl commits the crime of fentanyl delivery resulting in death. When as a result of the unlawful delivery of fentanyl in exchange for anything of value to another person, death to a person results from the proximate cause of injection, oral ingestion, or inhalation of the fentanyl. And that's the meat of the bill, the elements of the crime. The punishment is there as well in subsection 1. And then you'll see in subsection 2 that there's a medical exception for someone seeking assistance for someone experiencing a fentanyl overdose. Subsection 3 has some definitions, and that's one of the differences in the strike all is the definition there in paragraph A of fentanyl. We define as fentanyl as any fentanyl-related substances to include fentanyl analogs as set forth in the Controlled Substance Act, and that's the entire act because fentanyl is on Schedule 1 and 2 of the act. And then B was a definition that the House had as well. It was in exchange for anything of value does not apply to the act of sharing fentanyl when the sharing results in the proximate cause of the person's death. So I think the intent of the bill from the House was not to punish the user, but the dealer or the person that distributes the delivery of the fentanyl. And that's reflected as well in subsection 4, the stated legislative intent there. Subsection 5 says that the provision is in addition to any other crimes. And then subsection 6 would require the peer committee to report on the act. And then 7 subjects the entire section to a repealer on July 1st, 2025. That's the gist of the bill. Yes, yes.
Pass along a drug to someone and it is laced with fentanyl and results in the death of said user of said drug, then you were guilty of murder. And there was no knowledge requirement required in the House language that you as the dealer, whatever you want to call that, as the person passing along the drug to said end user, you did not have to know that it had fentanyl on it. You could have thought that it was just regular, whatever, and then it ends up having fentanyl on it, and the person dies, and you're therefore guilty of murder. I don't know constitutionally how that works. I don't practice it law, so I thought there were probably some issues with that. So we have a strike all that essentially is just sort of explaining section 2 requires knowledge of the person that gave you the drug, that it was in fact laced to heighten its effect or whatever with the fentanyl. And if you pass that along, knowing that it's laced with something and that person dies, then you have the punishment. But I wanted y'all to maybe know the difference between the two, because some of you may have liked the first version of it that does not require knowledge. This version does require knowledge. So there you go.
I guess my question or concern would be what street level dealer is going to know if it's got fentanyl in it or not. And if you put the knowledge requirement in there, probably only the person that manufactured the drug is going to know that. So would the legislation be worth anything if you're requiring somebody to acknowledge, hey, yeah, I knew fentanyl was in that and I gave it to them anyway. So I guess my question would be, and I agree with you on the murder part, that is a concern, but maybe instead of saying you got to have knowledge that it's fentanyl, reduce the charge from murder, if that's what was in the House bill, to manslaughter or something else, because I think if you put the knowledge component in there, you're just destroying the bill. And I don't see how anybody could truly, as a street level dealer, get prosecuted for that because they're not the ones manufacturing the drug. So, I'm not the lawyer in the room, but I would think that to hold the bill together, to actually maintain that it is still meaningful, that maybe reducing the charge to manslaughter rather than putting the knowledge component in there, that I don't think we probably ever get prosecuted. That'd be something that anybody in here would be open to, because I would like the bill to still mean something.
I appreciate the question. Again, that's why I wanted to point out the differences between the two versions. I think you raise a good point. I would assume that if you're a street dealer and you've been selling, ecstasy for a while, and now you've got a new batch of ecstasy that works way better and you're charging way more for it, I think you could certainly build a case that you knew it was laced with an enhancement of some sort. I'm not a prosecutor or defense attorney, so I'm just gonna throw that out there. So I think there are ways of proving that you knew that what you were passing along and selling, maybe for a higher price, and were advertising it as better than what you previously been passing out, maybe would point to some sort of knowledge. But again, I understand your question.
Well, I mean, I think that, they might know that it works a little better and has a little bit more kick to it, but a street level dealer is not a chemist, and I don't see how they would know for sure that it's fentanyl.
Right, Senator Simmons.
Thank you, Mr. Chairman. I think one concern that I had was addressed with the strike all, compare and contrast the difference between the House version and the strike all. But I guess I'm still concerned about college students. I don't know if you heard the situation where you have 3 or 4 college students together and they want to actually do drugs, so only one of them goes to get the drugs and comes back with the drugs. As a result, someone dies because they all users. And the question is, the friend that actually got the drugs brought it back, should that friend be charged with murder? The only thing they did was just pick it up and they just used it. That's the concern. I think it's still out there. Do you think that concern? Do you think the strike all addresses the situation that I described regarding local users using it?
I do. I think that's certainly a concern. I mean, I'm not for anybody doing drugs or passing drugs to be used, but I think you're talking about murder, which I think was the original language in the House bill. I mean, that's pretty serious stuff. And if you're simply passing a substance along to a friend at a party and it ends up being laced with fentanyl and kills that person, I don't know that the friend intended to kill their friend. I think probably just the opposite. They probably did not intend that. And if you're going to try and convict them for murder, I think that's a pretty heavy thing. So again, that's the substance of what this bill deals with. Why you bright people are sitting around this table to help figure out the best way of addressing that. Certainly fentanyl is a very dangerous substance. It's killing a lot of people, and we certainly need to do what we can do to try to combat that. But the House version I thought was kind of over the top, just me personally, but I will be happy to follow whatever y'all do. That's why this bill's in front of you, Senator Hill.
This bill does not have a reverse repealer in it, but I'm assuming that the House is probably not going to agree to these changes. So if the House does send this bill to conference, I would ask that we look at making something a little stronger than the knowledge element in here and try to get something that we can agree to that actually does something. Because I just don't see how any street level dealer that you can prove that they have the knowledge of chemistry that they knew fentanyl was in this drug. So I'd like to help on it. And I agree with you that it might be a little too strong the way it came from the House, but I think that we need to get something meaningful.
I agree. Senator Spark.
Thank you, Mr. Chairman. I agree, with Senator Hill to a great degree. She may have her JD yet because she is named, that's right, she's named the problem with the bill, and that's called specific intent. And I have a hard time seeing a murder charge without the specific intent. And then we know we don't have specific intent because in the language of paragraph 4, we turn around and tell you the intent of the legislature. When we start having to tell you the intent of the legislature in the middle of a criminal statute, it's clear that we don't have an intent crime. And while fentanyl is a major problem, and we would like to do what we can to reduce deaths, I don't think deciding who gets charged for murder based on what sharing means versus something of value, and then you throw in paragraph 2, if you ask for medical assistance, you're exonerated from the crime. So I could have sold it to you. And if you start having a problem, if I call 911, it appears we have less of an ability to prosecute. So I do think there's a lot of problems with the attempt. The attempt is pure, but it's a convoluted situation.
I just have a quick question, and I'm not sure who could answer this, but am I correct in understanding one of the purposes of this bill is to allow for prosecutors, where it says at the beginning, a person who delivers or causes the delivery of fentanyl, that this would allow prosecutors to go after the higher ups, so not necessarily, as Stephen Wolf called them, the pusher man, going beyond that to the people who actually, the bigger drug dealers that are lacing the drugs with fentanyl or causing these to come into circulation. This would allow prosecutors to go after them as well as, so I think that would be a good step.
31 and following, obviously, we don't need to probably have legislative intent in the bill, but if you're asking that question, it specifically says that the legislative intent is to assist and prosecute any person that sells or otherwise profits from the sale of unlawful fentanyl, the cost of the death. So yeah, the manufacturers clearly profit from that.
Right. Okay. Well, yeah, I think that Senator Hill has some great concerns, but I do think this is a good step in a direction that may help our prosecutors get some of these drugs off of our streets.
Maybe a reverse repealer amendment would be useful.
I would offer that.
Senator Hill offers an amendment to add a reverse repeal of this legislation. Any questions? All in favor say aye. Aye. Any opposed, nay. Yeah, it's out. All right. For any further questions, we're about to have to recess and go into the board. Any questions about the Senator Hill?
Just one more comment, what Senator England just brought up, from what I read, the vast majority of this stuff's being made overseas in China. So it's gonna be extremely difficult probably to get all the way to the manufacturer. So that's why I raised my concerns about who's stealing this stuff and how to prove their knowledge.
Exactly. All right. Motion is Taos Vision do pass. Strike one. All right. All in favor say aye. Aye. Any opposed, nay. The ayes have it. Thank you. We will just go ahead and rise for